On this channel, I have plenty of videos discussing cases where a person gets arrested, complaint gets filed, and later that complaint becomes what's called information. Alternatively, some clients get indicted with criminal charges right away. And then once in a while, we have a third category of cases where my clients received what's called a target letter from the United States Attorney's Office. In this letter, the U.S. Attorney argues and encourages the person to come in and talk, or at least engage in plea negotiations before the case gets indicted. In this video, I'm going to talk about these target letters, and then we're going to focus on a particular Ninth Circuit case where a person appeals his sentence, arguing that he received ineffective assistance of counsel prior to the case being indicted. And we'll see how that plays out for him. First, let's discuss the target letters. It is a letter that you might receive in the mail, and it looks something like this. Here's what it says. You are a target of an investigation in this particular district for possible violations of federal criminal laws. And usually the letter gives you, generally speaking, what are the laws that you might be violating or have violated in the past. And it might even give you some more information. For example, in this letter, it tells you that the investigation stems from this particular person working at a particular company. The purpose of this letter is to invite you or your attorney, if you have one, to contact me to discuss this investigation. If I have not heard from you or representative by a certain date, I will assume you decline this offer. So this letter you might receive from the United States Attorney's Office. And prosecutor who is assigned to the case might want to resolve the case prior to indictment. So it doesn't necessarily mean that they're asking you to cooperate or come in and talk to them about the case. That could be a possibility. But in most circumstances, what they're trying to do is start negotiations with you and your attorney. And hopefully, the United States Attorney's Office can reduce the amount of money they spend on investigation if you decide to plead guilty prior to indictment. Now, of course, there are advantages and disadvantages on taking the case to trial or engaging in plea negotiations with the prosecutor. So I encourage you to give me a call or give another reputable attorney a call who can work on your behalf in at least talking to the United States Attorney's Office. So one thing you don't want to do is ignore this letter. And now let's focus on a Ninth Circuit case that specifically addresses these target letters. The case is United States versus Gregory Olson, which is a very recent Ninth Circuit case from February 2021. Mr. Gregory Olson received a target letter from the United States Attorney's Office. In the letter, he's told that he's being investigated for wire fraud and tax evasion related to defrauding his church and its members of over $1 million. Now, in the letter, the U.S. Attorney's Office tells Mr. Olson to have his attorney contact the United States Attorney's Office because they're very much interested in resolving the case prior to indictment. When his attorney called the U.S. Attorney's Office, the prosecutor offered Mr. Olson to plead guilty only to tax evasion, where the sentence would be roughly 30 months of custody. Now, there was some back and forth between the prosecutor and his defense attorney. His attorney wanted to see all of the discovery, all of the evidence that the prosecutors had against Mr. Olson. The U.S. Attorney's Office refused to provide that information. After all, they argued that this case has not been indicted yet. This case has not been initiated in the criminal proceedings. So they were gonna play the game by withholding information, but then again, telling Mr. Olsen that he has this particular plea on the table. After some back and forth, the defense attorney told the U.S. Attorney's Office that his client was willing to plead guilty to tax evasion in return for a probationary sentence. The U.S. Attorney's Office replied by withdrawing the initial offer. 1 week later, Mr. Olsen is indicted by the grand jury. And then he's represented by new counsel. He pleads guilty to both counts and eventually gets sentenced by the district court to 48 months of custody, 18 months more than the initial offer was. Now he appeals his sentence, arguing that he received ineffective assistance of counsel when his first attorney didn't even tell him about the offer. Now, before we go into the specifics, talking about the offer and what the first attorney did or didn't do, let's talk generally about your right to counsel under the Sixth Amendment. In 1972, the Supreme Court of the United States tells us in Kirby versus Illinois that the Sixth Amendment right to counsel attaches only after adversary criminal proceedings get initiated by way of a formal charge, arraignment, preliminary hearing, information, or indictment. The Supreme Court gives us particular timeline, and anything before then, you do not have a right to counsel. And in the year 2000, in the case United States versus Hayes, the Ninth Circuit affirms a bright line rule, joining other circuits, that just like the Supreme Court said, no matter what, you do not have a right to counsel before official charges are brought and formal adversary proceedings begin. Even in the case like Hayes, where the prosecutors purposefully played a tactic where they didn't initiate the case, they didn't indict Mr. Hayes, because that allowed them to continue to record conversations between Mr. Hayes and a cooperator, and Mr. Hayes was not protected by having his attorney present next to him. If they would have indicted that case, the Sixth Amendment right to counsel would have attached. What does this tell us? It tells us that if you received a target letter, no matter what, you do not have a right to counsel. And later, you will not be able to say that your attorney had an ineffective assistance of counsel in helping you, that he wasn't good enough. And to focus on the particulars of this case, Mr. Olson's case, what can we say? There's evidence that his first attorney actually did a good job. And so the court says that even if they were going to move away from the bright line rule that they have and they followed for years, this is not a case for it. There's emails and other evidence to suggest that the first attorney did in fact tell Mr. Olsen about the first offer. So he would have lost either way. But for you, I encourage you to hire somebody good and somebody who knows what they're doing and what they're talking about. You need a good attorney who is willing to put in the time and negotiate with the prosecutor and not to ruin a case for you. If you enjoyed this video, please click like, subscribe, hit the bell notification button so next time I post, you'll be first to know.